be known, let it be known. Whatever you own, better lower your tone, You need to get gone, Stop sitting and listen, the mission is vicious, the victim is blown up. When I come back home from the combat zone, so the context no love. Navy SEALs concealed in automobiles. When the trail gets real, perpetuate the will to conquer this will. Still stuck in a position, is this in the fiction? The wicked is wishing we don't make a difference. Is risking convictions, isn't conditioned, it's strictly they own us. Show enough, infiltrated perimeters, advancing anonymously, but you'll remember us. Luck, no, raw skill, every move. Truckload, all steel, better move. Steady and pro, ready to go whenever you are. Let it be known, whatever you own, we going as hard. Stop sitting and listen, the mission is vicious, the victim is blown up. Showing love to no one that's showing up. Steady and pro, ready to go whenever you are. Let it be known, whatever you own, we going as hard. Stop sitting and listen, the mission is vicious, the victim is blown up. Showing love to no one that's showing up. Platoon, left, right, left. Platoon, right, left. Platoon, your left, right, left. 1, 2.
Sorry. Chambers of Search Rescue Deputy Brigham. This call will be recorded. Your message at the tone. Number 50. Hang up or press pound for more options.
Good morning, Chief Judge Matthew W. Brand. Of course, as always, this is William Lewis, 717-714. And I know it's starting to sound like I'm an annoying child, but the process is making it this way. But again, I'm calling for cases 446 and 7, and I'm doing so this early so I can leave this message on the record so it doesn't require any immediate action by your chamber staff. But as you know, over the past 6 to 8 months, we have repeatedly sought guidance from your office concerning jurisdictional and structural defects in both these matters. We followed the instruction provided by you all on the 30th of December to proceed by motion, and we filed accordingly, and thank you very much, Claire. But however, in case 446, the presiding judge, whose authority we were challenging within that motion, removed our motion for intervention from the docket in its entirety, along with a subsequent notice, which we placed on the docket yesterday after leaving a message with you, explaining that we were acting solely in compliance with guidance from your chambers. So now, as a result, there is no docketed record of our attempt to seek intervention or clarification. This raises serious procedural concerns because if the court determined it had authority to dismiss and or strike our felons, then it had a mandatory obligation to address repeated defaults. Yes, repeated defaults by parties who failed to respond and have never appeared despite confirmed services, including an ignored show cause order and 2 U.S. Marshal services in which you all charged us. The absence of enforcement in those issues while simultaneously striking our felons is the basis for the selective enforcement concerns, which was the core subject of the intervention request aside from the defects we previously mentioned. We are not attempting to circumvent any judicial directive. To the contrary, we are trying to determine what procedural avenue remains available to us now that our intervention motion and explanatory notice have both been removed, and where there's still no appealable judgment despite repeated dispositive actions, and the Third Circuit has already confirmed this, which we paid plenty of times to go up to. Therefore, we respectfully request clarification from your chambers, please, either by a return call or a docketed notice on whether we should resubmit the intervention motion, whether they're going to re-upload it, or whether another procedural mechanism is appropriate at this stage. So again, this call is for notice and clarification only. We are attempting to proceed correctly and preserve the record without being placed in contempt on the process. For as pro se litigants, this level of scrutiny was never applied to the defendants in either case, all of whom are represented parties, affiliated with represented parties, and represented by professional law firms. So this communication is offered in good faith to clarify the procedural posture of the case and to avoid any further misunderstanding regarding our intent or compliance. So as always, thank you very much for your time and reviewing this message when available. And take care, Chief, and the entire chambers, and I seriously mean it when I say I support you.